Welcome to Dose of Social, your recipe for social media success. In today's episode, we have social media lawyer Robert Freund. He's going to be talking to us about social media and legal.
Yeah, I'm excited about this one.
All right, Robert, thank you so much for joining us today.
Yeah, thanks for having me.
Can we get started by having you tell us a little bit about yourself and your background and how you got started in social media legal activity?
Sure. So I'm an advertising and e-commerce attorney. My practice is based in LA. And my background is that right after law school, I went to work for a big law firm. And I was there for about 7 years. And what I was doing was commercial litigation. So I was defending primarily big companies and high net worth individuals from a number of different types of lawsuits. And a lot of those lawsuits were false advertising class actions. And in California especially, that's a common thing that businesses can find themselves in trouble for. And that area of the law, advertising law in particular, was just inherently more interesting to me than a lot of the other things that I was exposed to. And so that's what I tried to focus on while I was there. And as time went on, we would have more and more clients come to us for sort of litigation avoidance help. Like, instead of get us out of this situation, it would be sort of like what you would expect a general counsel to do. Like, we want to run this new ad campaign, or we have this idea. Can you tell us what the risks are and maybe how some of our competitors have gotten in trouble for it, and what you suggest we do if we need to change anything? And I found that I enjoyed doing that work a bit more than the litigating part. And so when I decided it was time to leave that firm for a number of reasons and start my own thing, I thought, all right, the ideal career for me looks like doing that kind of advice and counsel and like stopping problems before they happen kind of work. And so that's what I do now. So most of my clients are consumer brands, marketing and advertising agencies, a few talent agencies, and occasionally an individual creator or talent or something like that. And I help them try to avoid the kinds of cases that I used to defend.
Nice. That's awesome. That's great. And so needed too in today's world. So why don't we get started? Oh my gosh, there's so many things you could say here.
I feel like we might want to start with copyright law just because there's so much that falls under that. One of the things we had talked about was reposting other people's content.
Yeah. That is a very common way to get in trouble.
Yeah.
I think there's a lot of confusion as to what you can and can't do with other people's content, and what happens when you post something on the internet or on a social media platform or what have you. I guess maybe a really quick overview of how it works would be helpful. So anytime that anybody creates an original work that has some measure of creativity, and it's the legal term is fixed in a tangible medium. So if I take a photo or I make a video or I write a screenplay or something, then I, as the author of that, automatically own the copyright to it. Copyrights don't protect ideas. I can't say, oh, I have an idea for a movie and then someone makes it. That's not something I can protect. But if I write the screenplay or if I take that photo, automatically I am the only person that can make copies of that work, and I have all of the exclusive rights that a copyright owner has in that work. There are benefits to registering the work with the Copyright Office, which I can get into if it becomes relevant, but generally speaking, like, when you make it, you own it. There's a really common, especially now with AI, misconception that if you post something that you own the rights in on the internet or somewhere else that you make it publicly available, that means you somehow lose some of the rights that you have in it. And that's not the case at all. Works that are in the public domain is a totally different thing. It usually refers to things that are at least 70 years old and the copyright is expired. It doesn't mean like it's on the internet and so it's fair game. And that's like a fundamental thing that people understandably get wrong, because it's like, why would you know that unless you looked into it? So when you post something on a platform like Instagram doesn't get any ownership in that work, and neither does anybody else. What you're doing is, per the terms of service of that platform, you're agreeing that Instagram can use that, whatever it is that you've uploaded, for a limited number of purposes. They can display it, they can let other people share it around on the platform, and a number of other things. But you still own it, and nobody else can download it and publish it somewhere else or anything like that. And the way that brands get in trouble for this, and these cases are filed dozens of times every single day, is taking a creator. It's usually like I'm taking a post made by some creator and I'm reposting it on my brand's page. And that is copyright infringement. You had access to it, you didn't have permission to reproduce it, you're posting it. That's an infringement claim, or that's something that would give rise to an infringement claim. And another big misconception is like, well, if I give credit, then that's okay. Giving credit has nothing to do with whether there's a copyright claim or not. If anything, a number of those cases get started, like somebody discovers they've been subject to infringement because they were tagged by somebody trying to give credit. So it actually like makes it more likely that you would get yourself in trouble. So I could get into like why those cases are filed so much, but I feel like maybe that's a good intro.
Yeah, I think one of the questions that we get a lot from clients is, oh, this creator, let's say it's a snack brand, for example, and they see a creator post a reel with their brand in it, and then they say, well, I'm going to take this and I'm going to repost it to my feed in a reel.
Right.
And we say, you can't do that. And they say, well, why? My brand's featured in it. So
yeah, that's another very common misconception, is that if somebody tags your brand or gives you a shout out or something, that means that you have permission to repost it or do something with it. And similar to giving credit, like just tagging the brand doesn't change the analysis at all. So what you should do is reach out to that creator and ideally have something written up that specifies what you get to do with it and for how long, and if you're going to compensate for them, what that looks like. But at a minimum, like, hey, we really like this. Do you agree to let us use it in this way? Respond in such a way that gives us that permission. Without that permission, again, it's a pretty straightforward copyright claim that you're subjecting yourself to if you just assume that a tag grants you any kind of permission, because it doesn't.
yeah, absolutely. And one of the things that we always share with our clients is if you do want to safely share it, share their actual content into your stories or the actual link. Don't rip it off their page and post it as your own.
Yeah, using the sort of built-in in-platform sharing tools is okay, because that's one of the things that in those terms you're agreeing that you let Instagram and other people do with your content. But yeah, you can get in trouble if you take a TikTok and download that and put it somewhere else or move it cross-platform, and I see that a lot in the cases that are filed.
And how about news sites, Robert? Because I think that sometimes is a gray area for some brands is, well, it was on a news site, I can reshare it. Is that accurate?
Yeah, no, that if you're the brand doing that, then it really doesn't make any difference. And most of the time, or yeah, it's fair to say most of the time, like legitimate news sites have paid licensing fees for whatever content they're using. So if you see like on a CNN piece, there's a photo of somebody who maybe is arrested or something, you'll see like a photo credit, like they've licensed that photo from Getty or whatever source it is. And just because now it's on CNN, like you will still have to license that from Getty also, or whatever the piece of content is. Or even if it's like a video that's gone viral, people will assume, well, it's been seen millions of times, or it's become a meme and so I can use it or something like that. And again, that's not the case. Like you have to figure out through what's called rights clearance is like who actually owns this. Have they assigned the right to give me permission to use it to somebody else? Like basically, like who do I need to talk to figure out how to use this? And that's another way that these copyright cases get filed, is somebody assuming that, well, it was on this news site or this other page, and so it must be fair game, and that's not true. And it's not always just brands. Like Snoop Dogg's been sued a few times this year for doing just that, like taking a viral news video of like tornado footage or something and putting it on his Instagram. He didn't figure out who owned it or who to talk to about that, and I don't think he's probably losing sleep over those cases, but it goes to show, like, no, that's not how it works.
So speaking of Snoop Dogg and celebrities, how does that work? Or how can we share with small business owners that you can't use celebrity photos for likeness?
Yeah, so it's a related issue that often comes up at the same time as copyright cases. So separate from copyright, there's what's called the right of publicity. And what that means is, and basically every state has some version of this law, is that everybody has the right to control the commercial use of their name, image, voice in some states, and their likeness, their persona. And in states like California, you don't have to be a celebrity to have those rights. Like if some brand just took a picture of me and posted it on their page, I would have a publicity rights claim against them. And so you see this a lot with brands who want to take advantage of the fact that maybe a celebrity wore whatever their product was. Like there's been a number of jewelry cases about this. The probably the most famous case, at least among lawyers who pay attention to this stuff, was Duane Reade Pharmacy tweeted something, I think in 2016. The actress Katherine Hagel was leaving their store, and they posted a picture that said, like, look who loves shopping at Duane Reade. And so she sued them she demanded $6 million. We don't know what they settled for because most settlements are confidential, but it was like, it illustrated the issue. Like just because somebody is using your product or is featured with it or whatever, or even if she had tagged them, by taking her image and posting it or running it as an ad, you're using her likeness commercially for advertising without her permission, and so that's the claim. And a lot of times that occurs at the same time as a copyright problem. There's a case that was brought against Volkswagen where there was some photographer who had set up like a mock shoot, probably for their own portfolio, some model in a field with a Volkswagen. And then Volkswagen used that in advertising, and so they had a copyright claim from the photographer because when he took the picture, he owns the rights to that work, and from the model because she's in this ad now without permission. So those are like closely related things that come up over and over again.
So with this celebrity part, so let's say she came into a store, posted a photo, could they then share that to their stories?
If it's for the copyright piece, that would be okay. The story would arguably be and probably be a publicity rights problem because you're then using that person's image commercially without their permission. And that's not the kind of thing that you agree to when you sign up for a platform like Instagram. I can't think of a case where just a publicity rights claim was asserted just for a story. I've seen it tried with copyright, even though it wouldn't really work. But it's certainly not something I would recommend, and you're sort of just like taking on risk for not a very good reason, I would say.
Yeah, absolutely. What about memes? There's a lot of brands that we've seen that want to incorporate memes or viral content into their social media strategy and incorporate it into their feed and actually use this content. Based on what you're saying, it sounds like that is also something they should be doing.
I mean, the thing with memes is it's not always black and white as to whether something's okay or not. In the last year and a half, probably at this point 20 brands have been sued for using the dude with sign. The dude himself, like the guy who holds that sign, assigned to F. Jerry Media the rights to enforce his publicity rights. And whoever the photographer was did the same thing with the rights to a couple of the original photos of him holding up the sign. And what these brands did was just like replace the text on the sign with whatever they're advertising. So each of them have been sued for copyright and publicity rights issues. I don't know what they settled for, but it's probably a nice side revenue stream for F. Jerry, which is also kind of ironic because like they became big by stealing content in the first place. But in any event, that's like a clear example of where using a meme can get you in trouble. The easy solution for that is just like have one of your employees hold the sign up and like write something different on it. I think that would probably have a similar effect. Like, I don't know that just that guy holding the sign makes that much of a difference in terms of the effectiveness of the ad, but it illustrates where that can become a problem. There have been other cases. I think it was the Success Kid meme was used in some political advertising, and the person who owned the rights to that photo successfully sued whoever was using that picture for supporting their campaign. For other templates, it's possible that whoever initially created it either doesn't care or maybe they intended for it to just be shared and they don't really have an interest in it, and so nothing would happen. But you can't always know that. It could be that somebody really doesn't like the fact that now brands are using this meme that they made, or they're not changing it enough to be transformative or what have you. And so the safer thing is, like, if you like a meme format and you can just recreate it yourself, then you're usually going to be in a safe position. Whereas if you just take whatever that picture is and change it, especially if there's a recognizable person in the original meme, then there's going to be risk from a copyright and publicity rights perspective.
Yeah, absolutely. That's good advice, and making sure that you have your own content with your own spin on it.
Yeah.
Definitely. How about giveaways?
Giveaways, big topic.
Yeah, Lindsay is excited about that.
Yeah, there's a lot there. The most immediate concern if you're running a giveaway is to make sure that you're not running a lottery by accident. And so the running a lottery is a crime in every state. And what makes something a lottery is three things. If you have a prize that's awarded, if you have that prize awarded by chance instead of by skill or some other like selection method, and you require people to give up something to enter, whether it's paying money or expending a lot of time and effort in order to enter. If you have all three of those things, then you have a lottery, and you can't run those unless you're the government or a charity in some like really limited cases. So if you see people promoting what they're calling a giveaway or a raffle or something, and it's like spend $1 at our store and you get, in order to get an entry, it's okay to require payment if you also provide for a free method of entry. So if it's just every dollar you spend in the store is an entry, that's a lottery. If you also make it clear to people like, hey, you can also enter for free by emailing us or sending us a postcard or something, then you're not in lottery territory. The catch is that you have to treat the free entries the same as the paid ones. So you can't have, if you buy the product, you get 100 entries, but only one for the free method. You're not treating them the same, and so the law says that's effectively the same thing as running a lottery. So it's not that difficult to set them up to be compliant if you want to have a paid method, but it's definitely something that needs to be paid attention to. The other things with giveaways are, depending on the value of the prize, there's logistical things you have to comply with. Like in New York and Florida, you have to register them in advance. You have to post a surety bond for it. There's record keeping requirements. Those are the things that I first think about when somebody wants to run a giveaway. There's also issues with what happens if you're using influencers to promote it, or you want people to share stuff as a way to enter, and rather than just sort of try to cover it all, I figure we can talk about whichever is most interesting.
I think the big one that I see a lot is the Instagram giveaway. Is like this photo, follow us, add a comment, get extra entries by adding more people.
Or sharing a story.
Or sharing to your story.
Right.
And I think a lot of people say, oh, this giveaway is not sponsored by Instagram, and just by using that language, it makes it okay.
Right.
Is that okay?
So that not sponsored by Instagram thing, that is something that the platform itself requires you to do in its terms. So it's like, it's necessary, but that's not the whole story. And all of the platforms have something like that in their terms. Like if you're running a promotion, you have to make it clear that it's not sponsored or conducted by the platform. When you're encouraging people to like or share or engage with content as a way to enter, that's okay from like the lottery consideration. The consideration element isn't there just by having somebody like something. But what that does present is an FTC endorsement disclosure issue. So the FTC's rule is that anytime there's a material connection between an advertiser and an endorser, like a brand and an influencer, then that connection needs to be disclosed, and it needs to be disclosed clearly and conspicuously. And a material connection is one that would affect, if the audience knew that it existed, it would affect the weight or the credibility that they assign to that endorsement. So if somebody says, hey, I love these shoes, I might treat that differently if I knew that the person's an employee of that shoe company. That would be a material connection that needs to be disclosed to me. On the question of, well, what's an endorsement? The FTC has made clear that liking a post or sharing it or commenting favorably on some piece of content can be an endorsement, and usually is. So what they say is if you are requiring somebody to repost or reshare, probably submit a comment as a way to enter into a sweepstakes, the connection between engaging in that activity for the chance to win something, that is a material connection that needs to be disclosed. So if you're going to have somebody share something, you need to also have them include a hashtag like ad or sponsored or sweepstakes or a giveaway or something like that, so that the audience understands, like, okay, this person isn't just liking it or reposting it because they think it's cool. Like, the reason they're doing this is because they want to win, or they want to enter to win whatever this promotion is.
Yeah, that's good advice. So essentially, if you are going to share in your stories, if I, as a consumer, I'm going to share a brand's giveaway, I want to make sure that I disclose that as a giveaway as well.
Yeah, and it's the brand's obligation to make sure that happens too. So anytime there's a violation of the FTC's endorsement rules, the liability is shared by the brand and the endorser and anyone who is involved in creating or disseminating the content. So that could be a marketing agency that you worked with if it was all their idea and they're organizing it and all of that. So it's important for brands to pay attention to what content is being put out by people they have a relationship with, like their influencers or affiliates or whatever, so that in the event of some FTC action, they can say, look, we have this monitoring and compliance program in place. We can't, depending on the size of your campaign, you can't be everywhere all at once. But if you're at least spot checking what's out there to make sure that the right disclosures are in place, then that can go a long way to protecting you.
What are a couple examples of language that a brand could use in their giveaway or sweepstakes post to make sure that they're covered?
Instructions, when you tell people how to enter, like, reshare this, and you can, a lot of times you want to be tagged and include, and just give them the hashtag you want.
Hashtag giveaway.
Yeah, something like that.
What about giveaways that I've seen brands do it where it takes them to the website, you have to enter your email, and you have to have, I think, specific terms and conditions on your website for that as well. Is that the case?
Yeah, so most states require that you have a set of official rules that you present to everyone and have them agree to as a condition of entering the giveaway. And they get pretty specific in terms of what you have to set out, like the start and end times, who the sponsoring entity is, how you'll pick the winner, when the winner will be picked, when the winner will be announced, the value of the prize, the expected odds of winning if they're known, and a number of other things. But yeah, there are services that will help you prepare those. I mean, it's something that I do, but sometimes I can understand why a brand might not want to hire me to do that. There are services that will handle all of the logistics and drafting the terms for you. And a lot of times that's a good value if you don't want to be doing all of that yourself and collecting all the entries and doing the draw and all of that. But yeah, you do need a set of official terms, and you need to present them to people and have them agree to them before they enter.
Yeah, the service that we were using was Gleam. I don't know if you're familiar with that one.
I haven't used them. I've had clients use Martin Kane a couple times, and they're pretty good in my experience and reasonably priced, I thought. But yeah, there's a number of them out there, and it's just good for peace of mind, and it takes a lot of the administrative burden off the brand.
Yeah, so takeaways here is make sure you're using a service that will produce those official terms for you for your giveaway or sweepstakes.
Yeah.
Good. I think that's really important to know, and I think a lot of education is still needed around this topic, so thank you.
Yeah, I feel like that's generally true for pretty much everything that I talk about. And to the FTC's credit, like they put all the information on their website, and sometimes they'll try to prepare digests for certain topics. Like they have a thing called Disclosures 101 for influencers. It's like, here's one page of things you need to know. But a lot of the stuff is very lengthy and not fun to read. And so it's understandable that people wouldn't know about this stuff or even think to look into it. But yeah, I think there's a big information gap between what the rules are and what brands understand or even know about.
And I think a lot of times brands think, well, it's not a problem until it is,
Yeah.
right?
Yeah, especially with things like copyright infringement. I'll hear from a lot of people that are like, well, I'll just take it down if they send me a letter. Nobody has to send you a letter before they file a federal lawsuit. And most of the plaintiffs' firms won't send you a letter first, or a lot of them won't. You'll find out that this is a problem because you'll be served with a summons for federal court, and then it's time to, then they'll, use that as leverage against you to settle something. And that's true with like consumer false advertising class actions too. I'll hear from people that are like, well, who is this person that's so upset over like a $3 product that they say was deceptive? I'll just refund them, or why don't they just reach out to customer service? That the reason they don't do that is because most of the time, it's not that you have an upset customer who wants to make a federal case out of something. It's there are lawyers that understand how much money is to be made doing that. They'll find you first, and then they'll run campaigns on Instagram to match a plaintiff with their case. So that's why when you see things like, have you used Bumble or played Diablo 4? You might get money, fill out this form. It's because they've already done the legwork of figuring out that they think you broke the law, and now they get somebody's name to put on that first page. And that's how it gets started. It's usually not the upset customer that thought boneless wings were not supposed to have bones, or whatever the like seemingly silly claim is.
Yeah.
It's lawyer driven, and so it's a mistake to think that you can just sort of like make it go away by being nice.
So talking about influencers, I saw you did a post about the risks with affiliate links. Could you talk more on that?
Yeah, what I was getting at with that one was about working with affiliates sort of as a general idea. And the main point that I was trying to make was that when an endorser, like an influencer or an affiliate, is creating content creating sponsored content where there is that relationship, then the law is going to treat that content as though it's the brand's own advertising. And so when you consider the FTC's rule that any claim that a brand makes in its advertising has to be truthful, not misleading, even if it's literally true, and substantiated, that also applies to claims that your affiliates make. And depending on the kinds of affiliate programs you're running, like not all affiliates really care about being compliant. They want to make as much money as possible. And so you'll see sometimes, especially on TikTok, I feel like I see this more often, where you'll have content that's clearly affiliate content, which is outrageous claims. Especially in like the supplement and health space, we'll see people like, I didn't need chemo because I took this tea or whatever. If some affiliate is saying that, the brand has to consider that's the same as it being on our website.
Yep.
And so it's very important for that reason, and there are other reasons why this is important, to have like very clear agreements with all of your affiliates, and like I was mentioning earlier, have some kind of compliance and monitoring program in place so that if you get these rogue people, or even people that are unintentionally just like overselling or saying things that you wouldn't be able to support, that you can cut ties with them and sort that out without having to get into some other dispute. So that was like the main issue that I wanted to mention, because like affiliate marketing is very attractive for brand owners and for the affiliates, but it's a mistake to think that you can just say, well, we didn't make that content, they're just an affiliate. No, that for all intents and purposes, that is as though your brand put all of that on your website or in a TV spot.
Yeah, that's really important to consider. I don't think people realize that, how the methods that they're using to sell the product are reflective of the brand.
Mm-hmm.
I think another piece we wanted to kind of touch on was the FTC's non-compete ban.
Yeah, that's been an interesting ride. So basically what happened was the FTC proposed this rule that would make non-competes illegal nationwide. That's already been the case in California, and it's still the case. But they wanted to make this a nationwide rule. And that was supposed to go into effect yesterday, I guess. Today's the 5th. But there is a federal court in Texas that entered an order essentially saying, no, you can't enforce this. And so it's not like for all practical purposes right now, the FTC might appeal that. They might not. I think it's unlikely that they would win if they appealed it. So that's essentially dead. If you're concerned about this, it's like worth checking in every once in a while. But for all intents and purposes, the FTC's non-compete ban is dead. And the reason, really briefly, is the FTC regulates consumer advertising to make sure it's unfair, or it's not unfair and deceptive, and they have authority to make rules around that under the FTC Act. They also police methods of unfair competition. But what the court determined in the challenge to the proposed non-compete ban was like, basically what they said was, well, the FTC Act doesn't authorize the FTC to engage in this kind of rulemaking about unfair competition as opposed to consumer deception. They exceeded their authority, and after the Supreme Court's ruling that essentially overturned Chevron, that allowed the court to more confidently say the FTC is overreaching here. They can't even make these kinds of rules that regulate businesses in that way. And that's what happened. So for all intents and purposes, businesses do not need to worry about the FTC's non-compete ban. But if it's news to you that non-competes are unenforceable in California, and I assume in some other states, then it might be worth looking at your contracts to see if there's some other way that you could achieve whatever goal you're trying to achieve through a non-compete.
Yeah, that's great advice.
I saw something you had posted about this and another lawyer on social media, and we kind of touched on this in the first episode about why you should never buy followers. So fake followers, I heard now, I don't know if it's Instagram or the FTC is cracking down on purchasing fake followers.
Yeah, it's the FTC, and they recently finalized a new rule that essentially is targeted at fake reviews and fake testimonials. It covers a number of practices, and one of them is expressly saying that buying and selling fake followers or fake indicators of social influence, which includes like fake engagement if you're buying likes or you're buying comments or anything like that, that is illegal. It violates this new rule, and it can subject you to FTC civil penalties. That idea is not new, though. Like the FTC brought a case against a company called Devumi, maybe like 8 years ago now, more than 5 years ago. And part of what they were accusing that business of doing was buying fake followers, or maybe they were selling it. I can't remember on which side of it was. But at the time, one of the FTC chairs said, buying and selling fake followers is illegal. It manipulates the market and erodes consumer trust, et cetera. And basically what the FTC was doing now is saying, like, rather than just have that be our enforcement position and our guidance, it's codified. Like, if you break this rule, we can more easily come after you for it. And this is also something that's been enforced through state attorneys general, which are basically, in many ways, they operate like mini versions of the FTC. There was a plastic surgeon who was sued by the Washington AG for a number of like sketchy online practices. One of them was he just bought a ton of followers and bought a lot of Google reviews. And he eventually agreed to settle that case for, it was either, I think it was $5 million. And a big part of it was he just bought all these fake accounts. So it's a terrible idea. I don't think very many people are doing it it's certainly not as much as they were maybe like 10 years ago when that was much more common. But yeah, it's not a good idea for sure.
Yeah, so for those of you listening, for the many reasons why you shouldn't buy fake followers, this is a big one.
Yeah.
Yeah, I mean, it's also just really bad. I mean, as you know,
It's bad for engagement.
It's
Yeah.
terrible for
It's
engagement.
bad for everything.
It wrecks your account, and it's really hard to undo that.
And-
Which is why some people will do that to their competitors and just like buy fake followers for people they don't like to tank their accounts, which is a whole nother
There's
thing.
people that do that.
Oh yeah.
And as someone who has manually removed thousands of fake followers from an
Yes.
account, I can say it's not fun.
Yeah.
And it's like you're playing in quicksand constantly, just trying to
Right.
get above.
Yeah. And I'll see people then buy the fake comments, and then when it stops happening, they have to keep paying. Or sometimes there was somebody, I can't remember who got called out because it was too obvious that they were getting the comments like all at once. So then there's like other services that will make sure that it's like staggered so it's not as obvious. And at that point, it's like, what are you doing?
Yeah.
What does that have to do with running a brand?
Vanity metrics.
Yeah.
That's what they're after. Thank you, Robert. This is so great. If we have some extra time, I'd love to ask you a couple questions about websites.
Sure.
For business owners and things that they should consider. So as a business owner, what are 3 things that someone should make sure they have on their website? I know accessibility was a big thing in the last couple of years, privacy policies, terms and conditions. For someone listening right now who's just starting a business, what legally should they make sure they're covered for on their website?
Yeah, if I had to pick 3, I think you identified the 3 that I would recommend. Maybe more immediately than like ADA or even a privacy policy is going back through all the content that's on your site and thinking about those copyright and publicity rights issues that we talked about at the beginning. Because like I said, there are so many of those cases filed every day, and they're not always filed against big businesses. It's people of all sizes. There was a real estate account on Twitter with like 300 followers that got sued for posting a picture of a house like 5 years ago where they posted it, and they're facing a federal lawsuit for copyright infringement. And the reason that happens is because the law firms that bring those cases, many times that's all that they do. And they know that they can settle those for somewhere around 10 or 15 grand a pop usually, because they know it's going to cost you more than that to hire a lawyer to defend it, and you probably don't have a defense anyway. So if you can imagine that those firms file maybe 20 of those a day, that's pretty good business. So they're very incentivized to find every instance where some photo exists on the internet, and just like, it's essentially like mail merging a complaint. They only have to change the person's name and like the photo description and send those out. So that's something I would certainly recommend doing, is go back through and do rights clearance for all the content that's on your website. Terms and conditions, especially if you're selling things like directly through your website, is one of the most important like first lines of defense as a business owner if we're talking about defending from a consumer class action. The reason why class actions are such a big deal is briefly, like, let's say that I claim that I wouldn't have bought this product if I knew that the countdown timer for a sale was fake. If I knew that it was always discounted, that's a pretty common type of claim. Like a lot of brands want to say, you know, was $100, now $80. It can't always be that, otherwise it's not a sale. So maybe there's a customer that's like, I wouldn't have bought this if I knew that I wasn't actually getting a deal. Maybe the product's a $20 item. That's not a big deal. It becomes a big deal if they bring that claim on behalf of every single person who's bought that product over the last 4 years. That might be all of your money. And they might also get attorney's fees. It's potentially like existential liability. One of the things that you can do to help avoid that is, this is not popular with the public, especially after the whole Disney Plus thing, but if you have terms and conditions or terms of sale that every customer agrees to before they complete the purchase, you can have them agree that they cannot bring claims on a class-wide basis and they have to arbitrate individually. And when the lawyers who go looking for these types of cases are trying to identify targets, the first thing they will do is go through the checkout process and see if there's an arbitration clause and see if there's a class action waiver. If there is, they'll probably go to the next website that's doing the thing that you were doing. If there isn't, then they know, like, okay, this is worth continuing down that road. So it's a relatively simple way that you can take that kind of liability for online purchases just completely off the table. There's another of other really important things that you can put in there to help you, like what law applies, where are we going to resolve disputes, what are you agreeing you're not going to hold us liable for, how do refunds work, how does shipping work. All that can be in there, and that can just help you avoid disputes and resolve them more quickly. So especially if you are selling things through the website directly, having those terms drafted and having them presented in a way that a court will say, yes, it's fair to enforce this, is really important to do. And then number 3, I would say, is probably the privacy policy aspect. Privacy is such a mess that, and what I mean is there's no federal privacy law. It's up to all the states to have different versions of it. And rather than just sort of agree like, okay, California's looks good, we'll just copy that, states take it upon themselves to make variations on it, and you have to sort of lay them all over each other to make sure that you're compliant everywhere. and it's a burden. And the burden differs. Like some requirements are triggered based on the size of your business or how many website visitors you have. But if you're subject to those laws, then it's important to get it right and to have not only the policy written correctly, but also make sure that the way you're actually handling the data and so on aligns with what you say you're doing. So at a minimum, I'd say it's worth talking to someone to see what do we need to do here. And then every type of, pretty much everything I do it's ultimately a business decision as to whether somebody wants to take on risk. Like if I said no to absolutely everything that any advertiser wanted to do that had some risk, there's not that many ads would be run. And so in order to make that decision, you at least have to know like what the rules are and where on the risk spectrum what you're doing or proposing to do lies. I would say, I mean, obviously I'm biased too because this is what I do, but it's worth understanding like what do I have to do from a privacy perspective? What are the ways that I can limit the risks that I might be taking on, and what are those risks? And from there, you can decide if it's worth it to spend the legal fees to make whatever changes might be recommended.
Yeah, that's great advice. And for someone who is just starting out, do they need to consult with a lawyer for this? What's the best first step for someone who maybe doesn't know where to get a privacy policy written, for example?
Yeah, for actually writing the policy, there are some things where I don't think you necessarily always need a lawyer for. Privacy policy is not one of those things, I'll just say that, because I've seen documents prepared by LegalZoom that do more harm than good for both policies like that and even sometimes things like terms and conditions. You'll see that, or I'll be able to immediately know this is a template that was not tailored to what this business does or what they're planning to do, and it's just not appropriate for them. And then undoing the problems that causes can be more expensive. So it's not necessary. Like you don't absolutely have to use a lawyer to help with that. But for compliance issues like that, I wouldn't feel comfortable saying that you can just take a template online and trust that.
Yeah.
For things maybe like an agreement with a vendor, say, or reviewing a contract that an ad agency sends to you, maybe you don't need a lawyer for that. Maybe it's written well enough and you feel confident that you understand what everything means and you're comfortable with that. Not everything needs a lawyer's eyes on it. But, I mean, unless you have really deep knowledge about how the privacy law works, it's going to be hard for the average new business owner to understand what they need to do.
Yeah, absolutely. So to that effect, if someone is looking for help, where can they find you?
I'm most active on Instagram and on Twitter at Robert Freund Law. I'm going to be starting a YouTube channel here probably in the next month or so. And there's all my information on robertfreundlaw.com.
Awesome. Well, thank you so much, Robert.
Thank you.
Always a wealth of information. And so important to know.
Yeah, thanks for having me.
Yeah, thank you. All right. Thanks for watching Dose of Social. We'll see you next time.
See you next time.